Well, I'm here today to talk about McDonald versus City of Chicago, decided in 2010, which incorporated the Second Amendment against the states. And there are a few things that we have to understand about McDonald, the most important of which is that it's impossible to understand the McDonald case without very quickly talking about the Heller case from 2008, because McDonald would not have been possible if it were not for the Heller case. Heller said that the Second Amendment to the United States is a fundamental right, and that there is a personal right to own a firearm. They didn't go into much detail about the kind of firearm, but Heller is important to understand because McDonald is the application of the Second Amendment, and whatever that means, and in this case it means an individual right to own or possess a weapon. McDonald is the application of that right against the states. And that is part of a larger process that the court has been engaged in the 20th century called incorporation. The Bill of Rights, most of the Bill of Rights is now incorporated against the states, and that simply means that the Bill of Rights, most of the provisions of the Bill of Rights now apply to the states in the same way that they have always applied to the national government. So in McDonald, the court took its cue from Heller that the meaning of the Second Amendment has a meaning that is a personal right. It's more than just a militia right to own a firearm. And this is now applied against the states. In the McDonald case, it was applied against the city of Chicago, which had rules and laws in place that effectively made it impossible for anyone in the city to own a handgun. Now, with that said, there are some things that McDonald said above and beyond a reaffirmation of the personal right to own a firearm and the application of that right against the states. And this part of McDonald echoes some of the fundamental parts of Heller, specifically that there are rational regulations that the national government and states can enact in regulating firearms. They said, for example, in McDonald, echoing the Heller case, that, for example, if states want to prevent felons from owning weapons, they can do that. If they want to prevent mentally ill individuals from owning weapons, however they define mentally ill, that was fine. And the majority of Heller and the majority of McDonald said that there can be regulations in place. Now, they didn't go much further than that in either Heller or McDonald, other than what is now considered, in light of recent events, rather prosaic or a very general suggestion that there can be some kind of regulation. Now, the key here in McDonald, then, going forward, is that this individual right to own a firearm is now recognized as a fundamental right. And fundamental rights in the American tradition, especially in the 20th century, if a right is considered fundamental, then there has to be a really good reason for the state to regulate that right. Obviously, the state can't ban that right or prevent its exercise. But in regulating it, there has to be a very, very compelling reason for the state to jump in and create regulation. And going forward from both Heller and McDonald, the discussion that we'll have as citizens, and certainly a discussion that the court will have, I'm sure, within a year or two, is to get down to business and think about two things. One, the extent of the constitutionality of the extent of regulations that will most definitely come on the national and state level in the next year. And also, it'll be imperative for the court to come up with a process or a set of rules through which they'll be able to balance or measure the constitutionality of legislation that comes after these regulations. They'll come up with a test or a set of rules for balancing what is now a fundamental individual right with the duty of the state to regulate rights.